Hello, everybody. Thanks for joining the Swiss Patent Litigation Fireside Chat. It's a 36th edition. I skipped the session end of February simply because there was no current decision to report about. But, well, things are different this time. You see the banner in the bottom if you have any questions or comments concerning anything I'm reporting about today. Just leave me a line in the comments under the presentation, and I will be more than happy to pick it up. So, yeah, it's the last Wednesday of March now, and there is, in fact, a new decision that was published end of February. And switching to the next slide here. This is what AI chose as an illustration for the background of that case. That's a Mammut in trouble in an avalanche, obviously, with an avalanche rescue device in front of it. So a more realistic illustration of that case is this screenshot here. That's from a promotional video from YouTube of the company Mammut, a Swiss company known for the outdoor equipment, in particular for snow sports, winter sports. And that's an avalanche transceiver. That's one of these small devices that are needed in order to spot buried people under an avalanche in order to be able to finally rescue them. So as this screenshot shows, voice guidance feature is unavailable in Switzerland, Germany, Austria, and the USA. And yeah, guess what? This is due to patent reasons. Which brings me to the case at hand, which is 2023-012. The device concerned is Ortovox S2 of Mammut. And Mammut had filed a nullity suit against Ortovox. So Ortovox is a patentee, and Mammut wanted to get this patent declared null and void. By way of background, for that litigation, there are corresponding litigation before the Unitary Patent Court. There were summary proceedings before the local division of Düsseldorf, and in these proceedings, Ortovox had sued Mammut for patent infringement, the very same patent, obviously. And the PI was issued, so Mammut was ordered to abstain from using this voice guidance feature in their most current Ortovox S2 devices. And yeah, this went through all instances up to the Court of Appeal of the UPC, and the PI was maintained. And main proceedings are still ongoing, and I will be coming to that in a minute, because it was interesting to see how these two main proceedings interacted with each other. So the nullity case, obviously main proceedings in Switzerland, and the infringement case at the UPC, where also potential nullity arguments were raised by Mammut. That was an interesting interplay between these two proceedings. So let's first have a look at the claim, and I will try to get me out of the way here. So that's a patent number on the top right, and the claim is on the left. So in English, it's just an avalanche transceiver. In German, it's one of these lengthy German words, Lawinenverschütteten Suchgerät. It's not quite as long as my all-time favorite, which was Laserflüssigkeitsstrahl-Lenkungsverfahren. I hope I got it right, but still it's a pretty clumsy word, Lawinenverschütteten Suchgerät. So avalanche transceiver, you know what that is. Now, the claim is pretty lengthy, but the relevant bits are the following. We have a loudspeaker, obviously, and then we have this voice message on the basis of at least one event, wherein the at least one event is associated with a search. So the relevant bit here, on the basis of at least one event, wherein the event is associated with a search. That triggers a voice message. And the other bit is at least one audio signal, which is not the voice message, obviously, it's another audio signal, which again is associated with a search. And just think of these audio signals as the typical bleeps that these devices make. And the voice message, well, that's just a typical voice message, a spoken word, some warnings or giving directions, right, left, go straight, whatever. So these are the relevant bits here. And in the characterizing part of the claim, it says that the at least one audio signal, the bleeps, during the output of the at least one voice message are suppressed or output with a reduced volume. So in simple terms, when there is a voice message to be output, it shouldn't bleep, or it should only bleep at a reduced volume. Yeah, that is pretty much it for the claim. And there was quite a discussion in the judgment at both courts, at the UPC and at the Federal Patent Court, about claim construction of the feature associated with a search. So in the preamble of the claim, this at least one event is associated with a search. And in the characterizing part, the audio signal is associated with a search. And the question was in claim construction, what is associated with a search? And the Federal Patent Court took an approach which I would call broadest reasonable claim interpretation. So the voice message could also be triggered in accordance with the specification of the patent by certain external disturbing influences, externe Störquellen. That may be the presence of a camera or a smartphone or another GPS device or electricity wires around the area where you want to do the search. All these external influences could trigger a voice message in accordance with the specification of the patent. So what the Federal Patent Court in the judgment said, okay, if the specification says this could trigger a voice message and for instance, warn the person who is currently doing the search of any external influences that might impair the reliability of any signals. If that is also something outlined in specifications, then it should be construed also as covered by associated with a search. So it does not necessarily need to be directly linked to the buried device of the person who is covered under the avalanche. But it could also be triggered by an external influence that would also be associated with a search in the sense of the specification. And I think that is perfectly right. The UPC took a bit of a different approach in the parallel judgment. And I'm sorry, it's in German, but I will roughly translate it. The UPC held that this event has to be in the direct functional relationship with the searching device, because otherwise this would not be according to the claim in connection with the search, which is, yeah, in my view, an pretty unduly limited interpretation of the claim in view of the preferred embodiment. And it ignores the mentioning in paragraph 18 that I had on the slide before, what could also be an external trigger to this voice message. So yeah, the UPC took a more narrow approach in construction of that feature. Interestingly, and this is the interplay that I mentioned in the very beginning, These two proceedings at the Federal Patent Court and at the UPC ran in parallel, and the expert opinion of the judge rapporteur from the Swiss proceedings had been filed in UPC proceedings. And the UPC took this opinion of the judge rapporteur into account and held it was wrong. So this second paragraph here on the slide explicitly says the judge rapporteur in the Swiss proceedings got it wrong. That is not a correct construction of the feature associated with the search. And the judgment in the Swiss proceedings thereafter, that was issued after the judgment in the UPC proceedings, the Federal Patent Court actually followed the assessment of the judge rapporteur and said, well, the UPC got it wrong. So that is a pretty obvious clash of claim interpretation between the two courts. I have much sympathy for the approach of the Federal Patent Court, simply because this is the broadest reasonable claim interpretation that I'm used to. The UPC took an approach that is really focused on the preferred embodiment, which I don't think is right, but that's maybe just me, and we shall see how that develops further in other cases, whether the UPC has a more narrow approach in claim construction than what is broadly considered the broadest reasonable claim interpretation, but that remains to be seen. So both these judgments, the Federal Patent Court judgment as well as the UPC judgment, are only first instance judgments. I have checked with the Secretariat of the Federal Patent Court only yesterday whether this judgment had been appealed to the Supreme Court in Switzerland. And interestingly, they did not know yet. So it had been sent to the parties on 12th of February and published, I think it was on the 26th of February or so. So the 30 days time limit for an appeal is long over. But still, obviously, the Federal Patent Court had not yet information from the Supreme Court whether an appeal had been filed or not. So I cannot say whether this judgment is final or whether an appeal is still pending. And yeah, same at the UPC. I think, no, honestly, I don't know whether an appeal is pending there or not. Maybe the parties have settled, but worth to know in any event, these two judgments that obviously have a different approach to claim construction on that feature are only first instance judgments for now. So, yeah, which brings me to some further aspects of that judgment where I don't have slides on, but still are worth to mention. The one aspect there in the judgment was that the plaintiff, Mammut, wanted to change the statement of claim only in the reply, so in the second exchange of briefs. And what they wanted to add was a declaration of non-infringement, a declaratory judgment of non-infringement, in addition to the invalidity complaint initially filed. And yeah, what the law requires is that there must be a factual connection between the two issues. Only then the statement of claim can be changed. And the judgment is pretty well elaborated on the reasoning why there is no such factual connection given here. And the reasons are that even though in both cases the patent claim has to be read on something, that something is fundamentally different. For invalidity, the patent claim has to be read on the prior art in order to come to decision whether it's valid or not. And for a declaration of non-infringement, it has to be read on a potentially infringing device, which is a totally different animal. And this is no basis for a factual connection between these two issues. So be aware, adding a declaration of non-infringement as a request only the second exchange of briefs, that's too late. Then another aspect that I found interesting in that judgment is that all the auxiliary requests filed by the patentee are only in an annex to the actual judgment. And when I first glanced through that judgment, I was very, very happy about that. And the reason is pretty simple, because normally you glance through a judgment and the first 20, 30 pages are only recitals of requests, which is really cumbersome. And I've never seen a need for that. And here in these nullity proceedings, Ortovox filed these claim sets not as part of their requests, but they requested maintenance of the patent in amended form according to auxiliary request, and so they referred themselves to a claim set in the annex. And this is the reason why this was also the approach taken by the court. And the good thing about this is that Mammut had challenged this approach and essentially argued, well, you have to formulate a self-contained request. You cannot refer to an annex. But the Federal Patent Court in this judgment held, well, that is a good approach actually, and doing it differently, reciting the claim wording in the request itself has no benefit, but would only impair readability. So from now on, I think the good approach in nullity proceedings will definitely be to simply refer to the auxiliary request in the annex. That keeps the judgment clean, it keeps the requests clean, and the bulky claim set can simply be dealt with in the annex. That's something that what we do at the EPO all along, and which is also good in civil proceedings now. This is decided once and for all. So I hope this will be good practice moving forward. And yet another aspect was dealing with the question of assessment of inventive step, and whether that is a question of law, and what the court can do itself in the assessment of inventive step, and what should be pleaded. And the court is very clear in this judgment in spelling out that even though inventive step is a question of law, it has factual underpinnings, and these factual underpinnings need to be pleaded. And if they are not pleaded, then the court has no chance to really deal with them. And the problem here in that case was that, and that's pretty typically made in nullity cases, the vast majority of the auxiliary requests are only filed by the defendant patentee with the last submission, which is the rejoinder. And in response to the rejoinder, you need to, well, it's a new factual allegation asserting a new claim set, and you need to respond to this new assertion. And you don't have much time for that. And I will show you the overview of time limits that the Federal Patent Court typically allows parties for their briefs, and I've marked it here in yellow. So comments on new factual allegations in the rejoinder, in ordinary proceedings you only have 2 weeks for that, so 10 business days. And you might get an extension of 1 week, but still 3 weeks is much shorter than what you would get during the normal exchange of briefs, which is 4 weeks plus 2 weeks, meaning 6 weeks. So dealing with all the auxiliary requests for maintenance of the patent in amended form, if you have new arguments against these auxiliary requests, you need to be quick and there is no realistic chance that the court later will do your job, because in inventive step is a question of law. As the court made clear here, it has factual underpinnings, and you need to plead these factual underpinnings. So this was, in my mind, again, a reminder by the court: be cautious and do your job, and we won't do your job otherwise. Here in that case, they went the extra mile and did some assessment of the auxiliary request, even though they clearly mentioned they wouldn't have to do that. But there is no guarantee that the court will do that once again. I think here it was pretty clear that they did not want to, or they wanted to prevent the potential perception that this was just a formal decision that has no real factual footing. It was just an issue for formal reasons, that the patent was not invalid, which was a reason why the court went that extra mile and provided arguments why these additional arguments of plaintiff did not have merit. So in the end, both the UPC and the Federal Patent Court held that the patent was valid. The UPC held the patent as granted was valid, and the Federal Patent Court only held that the first auxiliary request was valid. So in the end, this did not help much for the Swiss plaintiff Mammut and the defendant in the UPC proceedings, because they still infringed even on the limited version of the patent, and which is the reason why this voice feature is not available currently in certain UPC jurisdictions, the USA and Switzerland. So, which brings me to the next bit that I have on my agenda, which is the annual report that has been published a few days ago, the annual report of the Federal Patent Court. And yeah, it's always a bit my job to put all the numbers a bit into perspective, because the annual reports only compare the current numbers of the reporting year with the year before. I try to do that comparison with all years from the very beginning of the court. So the first set of numbers is the number of incoming new cases per year. The summary of the annual report says that the number of incoming main proceedings decreased sharply, which is right. That's a blue line in the middle here. Actually, it's an all-time low of 11 incoming new cases in main proceedings. It's the same number of incoming cases as in the very first year of the Federal Patent Court. So yeah, it is a sharp decrease, but yeah, if you look at the distribution of values per year, I tried to make a fit and then try to make a linear fit in order to guess whether there is a kind of linear fit that you could make for main proceedings. And in trying to do a fit, it essentially turned out that there is no fit. So the correlation of that data in order to make a linear fit is very, very bad. So any statistics with these small numbers are to be taken with a grain of salt anyway. So I really don't think that there is anything to worry about. It's just a normal fluctuation of values when you're dealing with these small numbers. But still, it's only 11 main proceedings incoming in 2024, and we need to watch that as time goes by. So the summary proceedings in red, that's a small decrease from an all-time high last year. 2 cases less than last year. It's still a pretty high number compared to the other years, but still, it doesn't mean much to me, to be honest. Then the number of concluded cases per year. I think the EPO would call that productivity. So the number of concluded cases went down a bit when you look at the total number of concluded cases in yellow, and broken down again to main proceedings, the blue line, and the summary proceedings in red. Both contributed to that slight decline of number of concluded cases, but still it's again, I think, the normal fluctuation of cases, which doesn't really tell me much, to be honest. The interesting part of these numbers is the number of settlements, which in the early years of the Federal Patent Court was extremely high in main proceedings. Even close to 90% of main proceedings were settled by compromise, meaning without a judgment being published, which is an enormous value, and that decreased quite a lot over the years, and we had an all-time low of, I think it was about 15% in 2020. And since 2020, well, if you might see a trend since 2020, the trend is showing up maybe. And in 2024, we had a share of 56% of all main proceedings that were settled by compromise. So more than half of the main proceedings were settled by compromise, which is a very high number in my perception. I would not yet call that a trend. There are reasons we have been involved in the one or the other case that has been settled, so that can be explained, and it is always case specific. So it's maybe not yet a trend, but it's a very high number, and the highest number by far in recent years of settlements in main proceedings. And in summary proceedings, not a single one was settled by compromise in the reporting year, which is pretty normal. Okay, which brings me already to hearings. So the next hearings that are scheduled at the Federal Patent Court, that are actually quite a few hearings that are scheduled. The next one is in early April, next week, 3rd and 4th April, 2 days actually. This is litigation between Imholz and Emil Giesler. That's a case that popped up quite a few times already. There was a first main proceedings in 12th of June last year. Then again on 6th of November last year, there were always witnesses heard, and I had reported on the blog already that I was sent out of the courtroom for some parts of the pleadings that I should not hear. Obviously, I've reported about that on my blog, and I had the assumption that the parties were not that far apart, so that a settlement might have been in reach, but apparently that's not the case. Maybe I should mention what's it all about. It's an assignment action. So Imholz is suing Emil Giesler for assignment of a patent application, and in turn, Emil Giesler has sued for monetary compensation of Imholz in case the patent application should in fact be assigned to Imholz. So they want their money back for their work on the patent application. So it's a typical assignment action, and maybe that's a reason why the parties are so have locked jaws, so intense. So again, a two-day hearing. Further witnesses are being heard. So if you're interested in learning about how a witness hearing is conducted at the Federal Patent Court, this is your chance to watch one. The next hearing that's scheduled is on the 9th of April, the week thereafter. That's litigation between Spirik and Takeda. That's about a European patent. The number is EP1644019. That's about lisdexamfetamine, and the drug of Takeda is Y1C. And it's a nullity action of Spirik against Takeda. The interesting bit again is, and that's not uncommon in pharma cases, the patent has lapsed meanwhile in the 1st of June last year, but an SPC is still in place, and that one even has a pediatric extension on top of that, and this will run until September 29. So in effect, it's about the SPC. But of course, if the basic patent is null and void, the SPC is too. So that's a background of this litigation. I won't be able to attend that hearing. I have oral proceedings myself at a different forum. But if anyone attends this hearing, I would be glad if someone would report me about this hearing. Maybe if someone attends, we can have a joint fireside chat next month about that hearing. Just let me know, drop me a comment or send me an email, and I will be happy to arrange for that. It would be great. And the last oral proceedings that are scheduled currently and published on the website of the Patent Court is on the 15th of April. That's litigation between Biogen and 3 parties, actually, Sandoz, Viatris, and MEFA. Our firm is involved on behalf of MEFA in this litigation. And Biogen is seeking PI against all these 3 parties. It's about dimethyl fumarate. That's a drug for the treatment of relapsing, remitting multiple sclerosis. And it's about a specific dosage regime again. So that will be, well, procedurally interesting. These proceedings are joint. And yeah, 3 parties, 3 generic firms on the defendant side in one oral proceedings. That might be interesting to follow for that reason alone, how that goes. And yeah, that was pretty much it, what I had on my agenda for today. And yeah, I will report about the oral proceedings that I had just mentioned in the next fireside chat, end of April, the last Wednesday of April. We will know more about that, and maybe the one or the other judgment has again been published by then. We are expecting at least one further judgment since quite a while. Maybe that one will be published next month, and I hope I will see you again next month. And yeah, now enjoy your lunch, and thanks for joining, and see you next month. Bye-bye.